The January 6, 2021 Capitol protest led to a wave of arrests and criminal trials across the country. Those trials are currently ongoing, and it gives us the opportunity to see a whole bunch of different criminal procedure happening in very high profile and very hostile cases in real time. Whatever you think about the January 6 protests, riots, I don't care what you call it. What should be acknowledged is the fact that many of the defendants in these cases have had their rights severely abrogated and curtailed by a court system that seems hell-bent on prosecuting them to the fullest while treating other protesters and rioters across the country in a completely different way. This has raised severe questions about whether or not the rights of these protesters are being honored. And we're going to talk about one of those today, and that is your Fifth Amendment right against self-incrimination. Now, when you have courts that are hostile to a defendant, sometimes the court will rule in favor of things that might not otherwise be okay. In this case, courts across the country are split on the issue, and that is whether the police can force you via a court order to provide biometric data to unlock an electronic device, which may lead to self-incrimination. I know that's a lot to say. They can force you to sit in front of your laptop so it can scan your stupid face and turn on, and then they can have access to your data, but that's what's going on. If that feels wrong to you, it should. And places like the Electronic Frontier Foundation are fighting against it, but as I said, courts are currently split on the issue. Let's see how it's being used in one of those Capitol rioter cases right now. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, go ahead, hit like, hit subscribe, turn on your notifications, make sure you don't miss any videos. And if you really like this video, drop a tip down in the comment section below. All right, here we go. Judge forces U.S. Capitol rioter to unlock laptop seized by FBI. Now, a brief lesson on the Fifth Amendment, the First Amendment, and compelled production of passwords. Most of the time, you are not able to be compelled to give over a password to the court. And the reason for that is twofold. One, you have a First Amendment right that prevents you from being compelled to speak in many situations. And some courts uphold that as applying to your right not to provide a password or be compelled to provide say a particular thing. However, other courts have held that that is not actually protected speech because it has no artistic quality or merit to it. It doesn't have a political message associated, et cetera, et cetera, et cetera. This is just a password that is used. And since it's a private thing, that you can be compelled to provide it under First Amendment grounds. However, then comes the Fifth Amendment, and this is the one that really sticks in the way. Under the Fifth Amendment, you have a right to be free from saying anything that could lead to your incrimination. You have seen people plead the Fifth when asked direct questions by the court, by Congress, by government officials, or whatever. It is your right to remain silent. It is your right to be free from issuing a statement that will be used against you in a court of law. And those statements by many, many courts have been held to be to include passwords. Because if a password unlocks a device with incriminating information on it, and you are compelled to provide that password against your objection. Now, importantly, you have to object to it and issue your Fifth Amendment or stand with your Fifth Amendment right to be free from self-incrimination. But if you do that, the court cannot compel you to issue that password. They cannot force you to make a statement. But the next part is tricky. Our devices no longer require a particular phrase. Many devices can be unlocked simply by looking at them and having them look back at us. They use radar information with a specialized camera in your phone, on your computers, wherever it is, to detect the features of your face. They've created a computerized map of it, and then that unlocks the actual device. You see this on any modern phone right now. You just hold it up and it looks at you. The other biometric information that is available, retina scans are something, but most commonly would be a fingerprint scan. and that is similar biometric data. Now, the courts have ruled that you do not have a protected privacy interest in your fingerprint or your face. So they can actually compel you to do this in some states. Like I said, courts are split on the issue of whether or not they can force you to provide biometric data to a device that you own for the purposes of unlocking it. So, my definitely not legal advice to everybody out there: do not use biometric logins. If you have biometric logins, highly recommended that you don't use them. They're convenient. They're wonderful. Heck, sometimes I still use them because of that convenience and wonder. But those biometric logins cannot be protected in many states from compelled production under a court order. And that is a critical piece of privacy law, in my opinion, that is being overlooked. The idea that someone could see you out in public is different from you subjecting yourself to a radar face scan to unlock a device, which may have incriminating info about you. Same goes for personal safes, by the way. Many gun safes, for example, have a very convenient biometric lock, which allows for very fast access to the safe. But if you have anything in that safe that could be incriminating, a biometric lock will not save you. A court can compel you to open a safe in a similar way as they can compel you to unlock a computer in the states where biometric data is not protected by the Fifth Amendment. The Supreme Court really needs to come in and issue a final ruling on this, and the Supreme Court needs to come down on the side that biometric data is a statement. It is a compelled statement of self-incrimination in these cases. We should not be allowing courts to get around the idea that they can't compel a password by compelling something that is the exact analog of a password for the purposes of producing this information. Because a person has to take a willing act to place their finger on a fingerprint scanner. They have to take a willful act to put their face in front of a camera that will recognize the face without any sort of mask or sunglasses or something like that, and will unlock a device. They have to make that decision consciously, and to me, that is compelling a statement. But apparently not in Washington, D.C. So let's read what's going on. A federal judge forced a U.S. Capitol rioter to unlock his laptop Wednesday after prosecutors argued that it likely contained footage of the January 6th insurrection from his helmet-worn camera. The judge granted the Justice Department's request to place Capitol riot defendant Guy Reffitt in front of his laptop so they could use facial recognition to unlock the device. The maneuver happened after the hearing ended, and Reffitt's lawyer confirmed to CNN that the laptop was unlocked. Investigators seized the laptop and other devices earlier this year pursuant to a search warrant. Reffitt has been in jail since his arrest in January. His case received national attention after his son spoke publicly about how Reffitt had threatened to kill family members if they turned him into the FBI. The case became an example of how former President Donald Trump's lies tore some families apart. Reffitt's son and daughter testified against him in court before the grand jury. This is from CNN, so there's an obvious bias going on. I don't know if you caught it in here, but there is an obvious bias on this. But they've got the story, and it's instructive for the overall point of, if you value your privacy and security, like any good citizen should, avoid biometric passwords. Avoid them. Until the Supreme Court comes in and rules on this, they need to be avoided. He pleaded not guilty to 5 federal crimes, including bringing a handgun to the Capitol grounds during the insurrection and obstructing justice by allegedly threatening his family. Felony gun charge was added last month and undercuts false claims from Trump and prominent Republican lawmakers that the rioters weren't armed and that they had no guns whatsoever. So certainly they've actually seized the gun from him, right? That they know for a fact that he... No, that's what they want the video for. Get this. The case raised intriguing constitutional questions about the right against self-incrimination, but Judge Dabney Friedrich agreed with prosecutors that the unlocking was within the law. You know, we, the government who want to prosecute this person, agree with the government, and we have determined that the rights of this person don't matter. In previous court filings, Reffitt's attorney said the search warrant for the laptop had expired and that Reffitt didn't remember if there was a password. As the court here noted, requiring a defendant to expose his face to unlock a computer can be lawful and is not far removed from other procedures that are now routinely approved by courts with proper justification. Standing in a lineup submitting a handwriting or voice exemplar, or submitting a blood or DNA sample, which of course, none of those things have anything to do with unlocking a device, which would have serious privacy concerns about it. Now, all of those things, right? You stand in a lineup, someone points you out, you submit a handwriting or voice sample, someone says, yeah, that looks the same or sounds the same as this person. Blood or DNA sample has direct access to whether or not you may have intoxicants that are illegal in your body. Sure, that's fine. Or a DNA sample can link you to another DNA thing. But unlocking a computer or phone goes a step further, because while there may be incriminating information in there, that incriminating information is along with a whole bunch of other non-incriminating protected information that you have an absolute privacy interest in. There isn't much in non-incriminating information that you're storing in your DNA or blood. I mean, you have DNA or blood information, that's what you have. But there's a difference between having an inherent characteristic or trait, such as DNA or a blood condition, than there is from having works that are protected from government search and seizure under your Fourth Amendment right to privacy. But, you know, what's it's the same as standing in a lineup, though. It is. I mean, so what if you have naked pictures of yourself on your computer or phone or whatever? Because it's the same as standing in a lineup, except it isn't. This is sort of the legal fiction that courts have created because they want to prosecute people. They want to put people in jail. When judges consider requests like these, Honig said they then try to strike a balance between respecting a defendant's privacy and other rights on one hand, and enabling prosecutors to obtain potentially crucial evidence with minimal intrusion on the defendant's rights on the other. What minimal intrusion is there? What minimal intrusion is there in forcing someone to unlock one of their devices? I don't know. By the time that Reffitt entered the courtroom, 2 FBI agents had set up his Microsoft Surface Pro laptop and 2 bags worth of technical equipment. Prosecutors have previously said in court filings they believe the laptop contained more than 6 gigabytes of videos that Reffitt filmed on a helmet-worn camera while he moved from the Ellipse to the U.S. Capitol grounds. In the video, if the videos are on the laptop, prosecutors said they could contain valuable evidence, like footage of the handgun that he brought to the Capitol or any comments he made about his intentions that day. Reffitt, who was wearing an orange prison jumpsuit, white Velcro sneakers, and a medical face mask, seemed uninterested during most of the proceedings. He often rubbed his eyes and at one point even leaned so far back in his chair that he had to catch himself from falling. Well, that justifies the invasion of his privacy, I suppose, but that is the reality of the court system right now. They take your privacy interest, which is actually very big, and they compress it into a tiny thing and say, well, you don't really have a privacy interest in your face. It's just going to be used to unlock the device that may contain all of your intimate life details on it. And since we do that, that's not really an intrusion at all, because we really want to get evidence that we don't have. We know we can't force someone to produce evidence against themselves, but we're going to force them to produce evidence against themselves because we really want to convict. Anyway, that's what I got for you guys. This is a big legal issue. It's an ongoing Fourth and Fifth Amendment issue. This should be ruled on by the Supreme Court at some point. And you know what? Maybe this would be the case to do it. I would recommend a different case personally, but this one could be the one. I don't know anything about this guy. I don't care if he goes to jail or not. I'm not saying he's innocent. I'm not saying he's guilty. Not up to me to decide that. What I do know is that this is a real ongoing privacy issue. It has strong constitutional implications, and we need to fight against government overreach in these areas with everything we've got. And if that means a bad guy has to go free to do it, then that's what that means. I'm sorry, but the police have a duty to produce the evidence on their own. You do not have a duty to give them evidence of your guilt. That is insane. It is against the Constitution, and it needs to stop. But I don't know. Drop a comment down below. Tell me what you think. I'm just a guy on the internet with a law degree. Anyway, I'll talk to you soon. Hope you have a good day. Peace. Peace.